stimulus, really, if you think about it. There are certainly Native American people still here. They haven't gone anywhere, despite the best efforts of the U.S. government to get rid of them. But they now represent a very small proportion of the people that actually live here. So it's interesting to look at this history and realize that everyone who comes here, not everyone, but at least the majority of the people that came here have tried very hard to protect their own kind of system, their own social system, their own culture, their own ethnic makeup, all those things from new groups. And then as some new groups assimilated, like Irish, for example, or Italians, who at first were, they wanted to exclude. It's like, you're not part of this club, but they came here anyway, and they kind of looked enough alike and acted enough alike that over time it was like, okay, you're part of the club. So really, in reality, if you look into the future and imagine the future of the United States, and if people, like excluding the hardcore propaganda and rhetoric of nationalists and all those people, if you kind of just ignore that stuff, which is virtually impossible to do, but this is a thought process here. We're just imagining for a moment. Over time, all the immigrants come here. If we just let anybody come from anywhere, no restrictions, over time, we would still have a national character. It would be different in many ways from what it is now or what it has been, but it would be something. You can't put groups of people together and not have them form their own kind of sense of, this is us. We live here. We are we. We are the people that live here. So the notion of assimilation, in a lot of cases, or most cases, or probably just about all of them, is this idea that people have that they want to protect what they have. They want to hold on to this thing that they like, that is the way they like it, and they don't want it to change. But change is growth. I mean, growth is change. If you stop changing, you stop growing, and you just basically become stagnant, and eventually you just die, because evolution is an ongoing process, not the evolution of the imagination that people think it is, like it's some sort of effort to get to, sort of natural effort to get to some kind of perfection. That's not what evolution is. It is merely adapting to circumstances. It's change over time. That is evolution. So evolution, the natural force of evolution, will change us over time to be something. I don't know what that something would be, but if you look at the current trends, and what's been going on for quite a while, it's not heading towards a pure white Christian majority. It's heading away from that here and around the world. I mean, as living standards increase around the world, more and more people are surviving, and they're growing up to do things and make families and expand their range of operations all around the world as people reject colonialism and the notions behind that. The colonial powers had their day. The Europeans went out and conquered large portions of the world and impose their will and their language and their customs and their everything on people. But, there's an ebb and flow to everything. And I think that trying to hide from the future that is sort of staring you in the face is just a lost cause. And So it's just interesting to observe the U.S. now in the strange place that we're in. We have people just fervently pushing back against growth, against change. It's very strange. You know, we have all these oddball things like let's get rid of critical race theory in our schools. We shouldn't teach things that make kids uncomfortable about race. So they're just going to just be uncomfortable on their own without understanding what's going on or why. I mean, you haven't solved any problems that way. You don't solve problems that way by ignoring them. Is that how you act when you're feeling sick? You just go, oh, I'm just going to ignore this weird pain in my side and keep going until I fall over, and then you go to the hospital and you find out you have appendicitis. I mean, it's like you can't ignore things. You have to pay attention to them. If your car starts making a very strange sound, figure out what it is and do something about it. And there's just too much pushback against that. Against, I guess it's against understanding. It's against knowing. I think the 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 intensity, the pushback, in large part comes from a subconscious understanding that you're not going to like what the answer is. I really think that's what it is. It's like I'd rather not know. I mean, how many people have done that? Like I just said, with illness, it's like something weird's going on inside me. It could be something serious. I'd kind of rather not know that if it is. So I'm just not. I'm going to pretend it's not there. That never works. It really never worked. And the same thing will hold true here in this country. If we just try to pretend that, like, oh, well, the only reason that there's a problem with racism is because people talk about it. If you just quit talking about it, it would go away. No, it doesn't go away. It doesn't go away even if you talk about it. But by talking about it and shining a light on it and exposing it, you make people aware. And some people, not everybody obviously, but some people will grow because of that. Will say, ah, I see this now. I didn't realize this before. The whole conversation about privilege, for example, white privilege. Like, what is that? What does that mean? So many people were really, really, really uncomfortable with that and pushed back against it. All it means is that there are certain problems that you don't face because of your perceived ethnicity. It doesn't mean that you've got things handed to you on a platter. It doesn't mean that by being white, you are like gifted with all this stuff necessarily, although in some cases maybe that has been the case. But I mean, I've enjoyed white privilege most of my life. And I have experienced racism in my life. And it was because I live in this liminal space. I've always lived in this liminal space where I'm not quite completely white in the standard sense of the word. I don't understand the culture or the ways of whiteness well enough to really fit right in. And at the same time, I'm not perceived as ethnic enough to be obviously excluded. So it's just been this weird push and pull and kind of like, what is this working? Is it not work? What's going on here? It's been very strange. But throughout, I have mostly enjoyed the benefits of white privilege because I present as white. You listen to me speak and you go, that's a white guy talking right there. Educated white guy. It's definitely a white person, you know? And so because I can present myself in that way, I've had privilege. I've had privilege. I have male privilege. I have all sorts of privileges. But that doesn't mean that I haven't had a really hard time and that I haven't had to really struggle at times. But it does mean that there are things that I have not had to fight against in order to get what I wanted or get what I needed or get where I was trying to go. And that's what privilege is. That's all anyone is saying. And that conversation has been very useful. And it has also been resisted with great force by those who just don't want to hear it. They don't want to feel that way. In fact, they've done surveys and found that there are large numbers of people who believe that the most discriminated against group, the group that is most discriminated against, is white people, white males. Why? Because that's the one being pointed out as being the one who enjoys the most privilege. So because you are in this privileged place and people are pointing at you going, hey, you've got all this stuff, they're like, hey, everybody's pointing at us. They're discriminating against us because of this thing. It's really ridiculous. But, that's just the push and pull of life and the world and stuff. But anyway, I'm going to run out of time again if I'm not careful. So we spoke a little bit about the DREAM Act earlier. And this is an interesting story here, entitled "The Supreme Court Case That Created the Dreamer Narrative." So let's find out a little bit more about that topic. So consider the backdrop against which Democrats in Congress are debating how to help the 11 million undocumented immigrants in this country. Border Patrol agents on horseback rounding up Haitian asylum seekers, toddlers huddled on the frigid floors of detention facilities under Mylar blankets, President Barack Obama's record deportation numbers, the post-9/11 transformation of border flows into matters of national security, multiple failed attempts at bipartisan comprehensive reform. In this tumult, one approach, one even endorsed by the Supreme Court, might seem deceptively obvious to any legislator tasked with fixing it all. First, protect the children. But the children have come of age, and many of them want otherwise. To anyone who has followed the serpentine turns of immigration policy in the past 20 years, it's clear that one discrete group of undocumented immigrants has obtained a special degree of sympathy. Young, high-achieving students who arrived here as minors with their families. Whether in news segments or State of the Union addresses, these immigrants became the sometimes reluctant faces of the DREAM Act, the landmark legislation never enacted that would provide legal relief to individuals who came to the United States as children and met other requirements. Obama's Deferred Action for Childhood Arrivals, or DACA, program similarly focused on childhood arrivals, helping some 700,000 immigrants get through college and build their careers. Amid all these twists, the term dreamer became omnipresent, helping proponents of these measures garner bipartisan support for what they described as sensible, narrow protections. In fact, there's another deeper reason this narrative has struck. Its unexpected origins can be traced not to congressional debates, but to the colonnaded marble temple behind the Capitol. In the 1982 case Plyler v. Doe, the Supreme Court held that all immigrant children, regardless of their legal status, were entitled to access public education, just like their peers born in the United States. Otherwise, the court said, these uneducated children would be prevented from contributing in even the smallest way to the progress of our nation. Thanks to that decision, undocumented children who were in the country at the time, as well as future generations, found ways to excel in American schools, even if they faced a slew of obstacles once they turned 18. But there's another, lesser-known side to the case's legitimacy. Even as it protected minors, it drew a bright-line distinction between undocumented children and their parents, a demarcation that endures today. Beginning in the mid-aughts, members of Congress, activists, journalists, and many citizens built on that legacy as they incorporated the term dreamer into common parlance as a way of humanizing a population that had long been called illegal. A specific narrative lay beneath that term. These people had been brought here as children through no fault of their own. They paid taxes and were highly educated, and for many of them, America was the only country they knew. They were innocent. This narrative has dominated the political lexicon of immigration reform for decades. Asked at a CNN town hall in July about a federal judge's decision to bar the Department of Homeland Security from processing new DACA applications, President Joe Biden urged the audience to imagine a scenario familiar to so many immigrants. You're 9 years old, your mom and your dad says, I'm going to take you across the Rio Grande and we're illegally going into the United States. What are you supposed to say? Not me, that's against the law. What can a kid say? Biden continued, raising his voice and shaking his arms. His brow furrowed. They've come here with really no choice, and they're good, good people. Biden was appealing not just to the large majority of Americans who support protecting undocumented youth, but also to a more fundamental conception of justice that emerged from the Plyler versus Doe opinion. Some legal experts today credit the decision with securing certain minimum rights for undocumented people and helping to immortalize the principle that the Constitution covers those outside the rigid boundaries of U.S. citizenship. Within the undocumented community, however, more and more people today are grappling with the unintended consequences of the court's opinion. In more than 15 interviews, current and former undocumented activists, lawyers, and scholars also uniformly rejected the term dreamer and said that narrative has helped them to get ahead at the expense of their parents who sacrificed their livelihoods to ensure their kids could have a better life in the United States. Excuse me. These sources variously called the dreamer narrative a myth, a fallacy, and a mistake, expressing reservations about the distinctions Plyler originally made between children and adults. When we say that kids and people like me who came when we were younger deserve special treatment, what it says is that the blame is on my parents, says Jonathan Jays Green, a co-founder of the Undocu Black Network, an advocacy group focused on the black immigrant experience, and now the vice president of programs at the Marguerite Casey Foundation. That because they brought me to this country through no fault of my own, they are the criminals. They are the villains of this story. Even Teresa Lee, whom many news outlets have held up as the original dreamer, because of her role in inspiring the original DREAM Act, is unsettled by the idea that her age and achievements set her apart from other undocumented immigrants. I've never personally identified myself as a dreamer. That was a label that was pasted onto me for political purposes, says Lee, a pianist who has selected to play with the Chicago Symphony Orchestra at age 16 and is now a professor at the Manhattan School of Music. She says she often asked journalists not to use that term to describe her. There was a worry, Lee eventually came to believe, that it would separate immigrants into deserving and undeserving categories. With Democrats in control in Washington, many advocates have been pushing the party to pass legislation that protects more than just undocumented youth. Very early on in the administration, we made decisions about fighting for as many people as possible, and specifically organized around immigrant youth, farm workers, temporary protected status holders, and essential workers, says Lorelei Prealey, co-chair of the We Are Home Immigrant Rights Campaign, who often speaks with the White House. Months into closed-door talks in Congress, though, that kind of wide-ranging relief has remained elusive for now. Last month, the Senate parliamentarian rejected two plans to include multiple pathways to citizenship in the Democrats' budget reconciliation bill, hinting that any proposals she might be willing to approve likely would focus on a narrower slice of the immigrant population, which, for reasons of political expediency, has often meant minors. The focus on immigrant youth is not new, of course, and in fact is more firmly ensconced in U.S. history than many Americans might realize. Almost 40 years ago, in the understudied Plyler case, the Supreme Court came inches away from declaring that the U.S. Constitution protects all undocumented immigrants, before one justice pushed to craft a narrow rule around children. Today, what once looked like a solution has become a kind of trap. If America is going to change how it deals with immigration, among the first challenges for advocates will be unwinding the legacy of this children-first approach and the powerful political currents it has swept in. In 1977, 10-year-old Alfredo Lopez and his siblings were sent home from school in Tyler, Texas, and told they could not come back. 2 years earlier, Texas had enacted a law that denied state funds to public schools for the education of undocumented children and authorized school districts to turn those students away. That summer, the Tyler Independent School District began requiring any student who could not produce a U.S. birth certificate to pay $1,000, approximately $4,500 in today's dollars, to receive an education that was free for anyone else. A group of families, with help from the Mexican-American Legal Defense and Educational Fund, or MALDEF, challenged the law in federal court as a denial of the equal protection guaranteed by the 14th Amendment. The parents, who were allowed to proceed under the pseudonymous last name Doe to head off attention from immigration enforcement officials and the public, argued that Texas law should be struck down because their children were being deprived of any education and because they were a politically powerless minority, according to court documents. Tyler's superintendent, James Plyler, argued that the children were a financial burden on the school district. On September 14, 1978, U.S. District Judge William Wayne Justice of the Eastern District of Texas held that the law was on the children's side, securing a temporary victory for the plaintiffs. According to a retelling of the case in the book The Schoolhouse Gate, a bouquet of flowers soon arrived at the judge's home, sent by 3 Mexican laborers who had spent $2 and change, presumably all they could afford, to express their gratitude. But plenty of other Texans directed their outrage at Justice in personal, insult-laden letters. "I would like to know your definition of illegal. Your name is Justice," wrote one El Paso resident, doubly underlining the judge's last name. The case was no less contentious once it was appealed and arrived at the U.S. Supreme Court. Although some archival material suggests a majority of the court instinctually wanted to protect the children, the justices also disagreed up until weeks before the opinion's release about how best to crystallize the protections in law. Even if undocumented children were persons within the meaning of the 14th Amendment, they also had to be within the jurisdiction of the United States to be guaranteed equal protection, the school district's lawyers argued. The Supreme Court's jurisprudence up until that point had established that laws that abridged an individual right based on certain protected traits or identities had to pass a higher legal standard. The segregation statutes that were challenged in Brown v. Board of Education were struck down on this basis. According to Justin Driver, a Yale Law School professor and author of The Schoolhouse Gate, racial classifications had been accorded strict scrutiny, meaning that almost inevitably failed the court's exacting legal test, but unauthorized immigrants had not yet been deemed part of a suspect class, like the children in Brown. The swing justice at the time, Lewis Powell, a Richard Nixon appointee, was particularly torn. Powell had served on the Richmond, Virginia School Board, including during the raucous aftermath of the Brown decision and the passionate resistance against the court's mandate. David Levy, Powell's law clerk working on the Plyler case, said in an interview that on the morning of oral arguments his phone rang at his desk and he heard the justice's southern drawl on the other end of the line. "David, come talk to me." The jurist was still of two minds. He told me that he was tending to think that these children needed relief, says Levy, who later served as chief judge on the U.S. District Court for the Eastern District of California and is now a professor at Duke University School of Law. It wasn't like they got to vote about whether they would come across the border or not, but here they are, and it's not in anybody's interest that they become a permanent underclass of residents. Powell's personal correspondence, housed at the Washington and Lee University School of Law and reviewed by Politico magazine, reveals that the justice received early drafts of the majority opinion by the progressive Justice William Brennan, and that Powell ultimately persuaded Brennan to significantly narrow the opinion's scope. The court feasibly could have extended the 14th Amendment's protection to all undocumented immigrants instead of just children, Driver says. Indeed, the correspondence shows that the court considered enshrining such reprieve into law. When Brennan circulated a first draft of his opinion to Powell and the other justices in the majority he was trying to compose, he left open the possibility that the protection that applied to lawful residents should apply with even greater force to undocumented residents because they were part of a discrete and insular minority that triggered more intense judicial review. But Powell, who held outsized sway as the fifth vote, saw undocumented adults as lawbreakers. "I could not agree to this," he wrote in an early draft of his response to Brennan. In his view, any alien beyond school age is guilty of a crime and subject only to due process, not special protection under the law. Powell wrote the draft sweeps rather broadly, and that he hoped Brennan would write a new opinion focused so specifically on children that I can join it also. The justices kept going back and forth over the next 6 months trying to reach a majority agreement. According to legal journalist Linda Greenhouse, Justices John Paul Stevens and Harry Blackmun suggested Brennan could simply omit the reference to all undocumented people as forming part of a suspect class. Instead, Brennan redrafted his opinion so it unambiguously rejected the claim that undocumented adults were part of a protected class. On his copy of a new opinion, a satisfied Powell noted, "WJB in this draft has adopted the substance of my views. I believe I can join." When the court announced its 5-4 opinion on June 15, 1982, the Tyler families emerged victorious, securing equal access to education for all undocumented children across the country. What's more, the court articulated a basic principle of law that at the time was not well settled. The Constitution preserves some rights for individuals that do not depend on their citizenship status. When the Constitution says person, that means person. And that is still not a lesson learned today, says Thomas Saines, the current president of Maldev. The opinion was not without opposition. One John Roberts, the court's future Chief Justice, who was then a Justice Department attorney, co-wrote a memo to the U.S. Attorney General disparaging the decision and arguing that the DOJ should have filed a brief siding with Texas. But while the opinion was a triumph for undocumented people, it also excluded most of them, drawing a stark legal line between undocumented children and adults and the protections afforded to them by law. "We reject the claim that illegal aliens are a suspect class," Brennan wrote in the final opinion, adopting Powell's view. "Indeed, entry into the class is itself a crime." Yet Driver pointed to a peculiar outcome of the Plyler case, whereas many hard-won civil rights cases on segregation, abortion, same-sex marriage were decided after years-long social movements, he says. "If anything, it seems to me that you might be able to make a more plausible argument that Plyler v. Doe helped to produce a social movement." Well, there's more of this, but I'm out of time. So anyway, you have been listening to CU Immigration here on WRFU LP Urbana 104.5 FM and UPTV. I hope you can join us next time for more stuff. And until then, take care of yourself, be well, and we'll see you later. Bye-bye.